Greetings to the students of the DePaul College of Law and any other interested viewers. This video is part of an ongoing series of videos guiding you through the legal research process. This video will be a survey of the types of primary authorities you'll encounter, which we will cover in greater depth in future videos. We commonly call any type of source of legal information an authority, and I may sometimes use source and authority interchangeably. There are two important distinctions between the types of legal authorities that you'll encounter. Those are the distinctions between mandatory and persuasive authorities, and between primary and secondary authorities. The first distinction is between mandatory authorities and persuasive authorities. A mandatory authority is a law that is binding on the court in that jurisdiction. The court will need to rule in accordance with that law. This can be a constitution, a statute, or a precedential case from a higher court. A persuasive authority is a legal source that the court is not bound to follow in making its ruling, but might nonetheless use to inform its decision. A common form of persuasive authority is an opinion from another jurisdiction when there is no rule on the topic in your jurisdiction. Always be aware of when you are using an authority that is only persuasive, and, as a general rule, only rely on persuasive authorities when a mandatory authority on point is unavailable. The next distinction is between primary authorities and secondary authorities. Primary authorities are legal sources created by government bodies, and only they have the force of law behind them. Secondary authorities are highly valuable resources for researching the law, as they explain the law and help you find primary authorities, but they do not have the force of law. You can see how primary authorities can be either mandatory or persuasive, depending on the jurisdiction. While this video focuses on primary authorities, the next video will explore secondary authorities. To understand the different types of primary authorities, you also need to understand the different branches of the government, which each create different forms of law. Also, you should understand that the federal and state governments have largely parallel structures. Legislatures are the bodies of elected representatives who vote on the laws that will be enforced in their jurisdiction. The United States Congress is a legislature, as are state legislatures and the local representative bodies like city councils. The laws passed by legislatures are called statutes. When most people think of laws, they're likely thinking of statutes. Statutes are generally available in two forms: session laws, which contain the language that was directly voted on and passed by the legislature, and statutory codes, which rearrange the permanent statutes to put them in a topical arrangement. The main way that researchers navigate statutes is through statutory codes. Codes are the compilations of every permanent and currently in force law that has been enacted by a legislature. Codes are organized according to topic and have many levels of organization, with titles, chapters, sections, and subsections all nesting within each other. Statutory codes can be published either by the government or by commercial legal publishers. The commercially published codes are called annotated codes because they contain many references to other authorities that relate to each section, including lists of cases that have interpreted that section. The government-published versions, called official codes, have very few annotations, so they are a bit less useful for legal everyday research, though they do have their uses, particularly for researching old versions of statutes. The federal statutory code is called the United States Code, and West and Lexis each publish their own annotated versions. While the state of Illinois does not publish an official statutory code, the unannotated equivalent is called the Illinois Compiled Statutes. West and Lexis each publish their own titles called the Illinois Compiled Statutes Annotated. While codes conveniently organize statutes by topic, they are not how laws first get enacted. The version of a statute as it appeared before it was reorganized into the code is called the session law. You may need to find the session law version of a statute for a few different reasons. For one, some statutes are referred to by their session law organization rather than how they appear in the United States Code. As an example, while the employment discrimination provisions of the Civil Rights Act of 1964 appear at 42 U.S.C. Section 2000E, they are typically referred to as Title VII, which is taken from the session law organization. Also, the codes don't contain every public law. Many important laws, such as appropriations acts, don't appear in the code because they don't have an ongoing effect. Federal session laws are collected in the statutes at large. Illinois session laws are published in the laws of the state of Illinois. The federal government and each state government have a separate court system which hears cases that fall within its jurisdiction, and each court system has a hierarchy of courts. When an appellate or Supreme Court declares that an opinion it issues is for publication, that opinion is binding precedent to the courts below them, and we call such opinions case law. Case law might interpret how a statute applies to a specific situation, or it might determine whether a statute is constitutionally permissible. There are also certain areas of the law that, due to quirks of history, are primarily governed by case law rather than by statute, and you might hear such cases described as common law. Cases are published in various series called reporters, which have both official versions and commercial versions, the latter of which are commonly called regional reporters. Like with statutes, the regional reporters have annotations that the official reporters lack. The only official reporter for the federal courts is the United States Reports, which publishes cases by the United States Supreme Court. Most states have 2 or more reporters, with reporters corresponding to the state Supreme Court and the Intermediate Appellate Court, and sometimes to local courts as well. In Illinois, we have Illinois Reports for Supreme Court decisions, and Illinois Appellate Court reports for the intermediary courts. You are more likely to deal with regional reporters than official reporters. The regional reporters collect all published cases from each state in a given area. These regional reporters add headnotes to the beginning of cases, which excerpts the points of law that are inside the cases. West's headnotes are direct copies of the headnotes in the print reporters, while Lexis's are not exactly the same, but are largely equivalent. The executive branch is composed of many departments and agencies that are tasked with implementing the statutes passed by Congress. The various forms of law that are created by executive branches are referred to as administrative law. Because of the need to rule on the finer details in these areas of the law, it is hard for legislatures to draft suitable statutes, so they delegate some of their rule-making authority to agencies. These regulations have the force of law, and are also subject to review by the courts. Certain agencies are also given the power to hear certain types of disputes, and will publish their decisions on those disputes. Some of those decisions are precedential and binding on that agency, which makes them analogous to case law, while other decisions are non-precedential, and therefore do not have the force of law. Finally, the President also issues certain orders independently of the agencies, which can have different types of effects. Administrative law can appear in a variety of sources. Just like with statutory codes, permanent regulations are also organized by topic and placed in codes accordingly. At the federal level, there is the Code of Federal Regulations, which is republished in print every year. In Illinois, there is the Administrative Code. All regulations, before they enter the Administrative Code, will first be announced and then later finalized in an administrative register. At the federal level, there is the Federal Register, and at the state level, the Illinois Register. There is no uniform location for decisions issued by administrative agencies. Each agency publishes its decisions through different channels, and commercial republications of the decisions are equally diverse. If you have any questions about research strategy or locating a legal resource, don't hesitate to contact the reference librarians, either by chat, email, or scheduling an appointment with us.